All right, guys. We are here today with Niv Davidovich, who is an attorney at law. He's a manager and partner at Davidovich Stein Law Group. Niv is an experienced litigator and counselor with a diverse legal experience representing developers, landlords, owners, property managers, architects, engineers, contractors, and investors in contract construction litigation, lease negotiation, land use, landlord and tenant litigation, and other real estate matters. Niv has received his Bachelor's of Science in Electrical Engineering from the University of Southern California and his Juris Doctorate from Southwestern College of Law. I am Dennis Maynard. I'm a real estate broker here in Los Angeles, California. I am CCIM and active in the community. And on a side note, I've often thought that the only thing more confusing than California tenant laws is the IRS tax code. So we will be posting this content later as a recording. Myself, Maynard Company Realtor, the content of this Zoom does not constitute legal advice. If you have any questions regarding your legal rights or legal obligations, you should consult with an attorney, such as Niv. I will post the links to the chat and Niv's website. I will post the links to Niv's website in the chat. There will also be a Calendly invite should anyone need a consultation regarding buying, selling, or investing in real estate. Last, please hold questions till the Q&A. You may post questions in the Q&A for later if you'd like in the question and answer section. Keep all mics muted. And then when we are taking questions, please raise your hand so we can call on you. Specific legal questions regarding personal situations should be addressed directly with Niv in a private consultation. And with that, I'm going to turn it over to Niv.
All right. Good evening, everybody. Thanks for joining us today. What I wanted to do was take you through some of the new stuff that's going on statewide in 2024. Some of the new stuff that happened last year in Los Angeles, and then take your questions and see what you guys are curious about. Let me take you through some of the stuff that's going on statewide in 2024. The biggest one is called SB 567. SB 567 is an amendment to AB 1482, and as you probably already know, AB 1482 was the 2022 Tenant Protections. Well, they called it the Tenant Protections Act of 2019, but it became effective on 1/1/20. And that was the law that essentially established eviction control and rent control statewide in California to pretty much all the multifamily property that's older than 15 years on a rolling 15-year basis, right? So originally, at the time, it was very bad, but compared to other kinds of rent control, it was not so bad. Then they decided, well, we should make it worse. So that's what they did. Starting April 2024, and I'll explain to you why even that part is not true. But technically speaking, effective April 1, when you do for example, landlord occupancy eviction, and this might be relevant to you if you are in the condo or single family home brokerage business, because your clients might be buying a house with a tenant in it who doesn't necessarily want to leave. Well, in a single family home, you could probably get around this, but it's a different issue. But if you want to do a landlord occupancy eviction of any kind, it used to be you just gave a 60-day notice. You said, we're doing a landlord occupancy eviction, give them a month's rent credit, and that's it. Now what you have to do is you have to say who's moving in, what their relation is to the landlord, and then that person has to move in within 90 days and stay for 12 months, okay? The only exception to them staying for 12 months is death. And that's not a joke. That's really the law. If it says in the law that if the person who moves in dies less than 12 months, that's okay. You won't get in trouble. But if they actually move out less than 12 months, so less than 12 months from when they moved in, you technically speaking have to offer the old unit to the old tenant at the rent that he used to be paying, right? Now, it sounds very nice for the tenants. It sounds a little bit disheartening for the landlords. The truth is that most people who do honest to goodness landlord evictions, they're not doing the person who's coming in is staying for at least 12 months. Second, it just has to be their primary residence. So it doesn't mean that they are under house arrest. They don't have to spend a minimum number of nights in the property. It just needs to become their primary residence. So just recently, I was talking to a couple who wanted to let their son in to move into a single family home that they owned, but he just joined the Coast Guard and he probably wasn't going to be around for that long. But he still needs a primary residence. Even if you're in the military or if you're, playing bass in Taylor Swift's band and you're on tour, you still need a place to get your mail. You still need a place to register your car. So even if you're there 2 nights out of the year, you could still have a primary residence. You're just busy the rest of the time. You don't have to stay there. You just have to have a primary residence there. So that's that. And then the last thing is, if let's say you have your kid or the parent or something like that, they move in, they're like, I really don't like this neighborhood anymore. And 6 months later, they leave. Do you have to give that notice to the tenant? Yeah, technically by law. By that time, the tenant's probably living somewhere else. They probably signed a 1-year lease to go live somewhere else, or they bought a house. The chances that the tenant is going to say, yeah, I'll move back after moving their whole life within that 1-year span, I'm not saying it's impossible. I'm not even saying it's almost impossible. I'm just saying the chances that they'll take you up on it fairly minimal, and they have to let you know within 30 days. So unless the rent differential is so big that they're willing to re-disrupt their lives to move back and break their lease wherever they are to move back, chances are it's not going to happen, right? So that's basically that in terms of landlord occupancy. In terms of the other big change that they made, it was to substantial renovation notices and evictions. Substantial renovation eviction basically means that you are going to take a unit and substantially renovate it. They are very, very careful to note, both in the old version and in the new version, that cosmetic changes do not count as substantial. It does not matter how much money you are spending. It matters what kind of work are you doing. So if you decide, I'm going to renovate this apartment with nothing but Carrara marble from Italy, and I'm going to make the floors out of platinum, and I'm going to make the walls out of diamond, and it's going to be the most expensive renovation that's ever been done to an apartment in the history of man. But all you're doing is changing the floors and the walls and some kitchen cabinets even, and things like that. That doesn't count as substantial renovation, even if you spend $50 million. Alternatively, you could spend $10,000 and have a gut renovation because you're putting in new plumbing, new electrical, and that counts as like maybe some new cans. In other words, some new recessed lighting, maybe changing out some of the plumbing. So you're doing gut renovation to the bathroom and the kitchen. That does count as substantial renovation, even if you're not spending that much money. So the dollar figure, not relevant. The type of work you're doing. And so it has to be substantial renovation to an electrical, mechanical, plumbing, or electrical, mechanical, plumbing, or structural system. Okay. So for example, seismic retrofit, that would count. The other seismic retrofit would probably not get you past the other issue, which is that it has to be the kind of work that would require the tenant to be out of the property for 30 days. In other words, you cannot complete this work in 30 days. Who's the judge of how long it takes? It's a reasonableness standard. But the reality is that most time if a contractor comes and tells you I can finish this in 2 weeks, that's nonsense. It probably is going to take a month, right? So anything that will take somewhere between 2 to 6 weeks, that's going to qualify. So if you're telling me all you're doing is one bathroom and it's not a gut renovation to the bathroom, that's probably not going to fly. If you're doing gut renovation to a bathroom and a kitchen and you're replacing the pipes that are serving all of the different faucets and toilets and showers and all that stuff, that'll probably work, right? It doesn't have to be that. It can be a combination of a bunch of things. But altogether, it has to be enough to be 30 days of the tenant not being able to live there, right? And that's usually why we use examples such as electrical, because without lights and without electricity, they can't live there. If you're taking out a bathroom, if you're taking out the kitchen, they can't live there. And so if that's going to be 30 days without a kitchen, 30 days without a bathroom, or some combination of the two, you're probably going to qualify. The other thing is, before you didn't have to have the permits, and you didn't actually have to do the work. You just have to have intended to do the work, and you just have to tell them what work you were going to do in the 60-day notice. Now, you not only have to tell them what work you're going to do, you have to have the permits in hand and give them a copy of the permits with the 60-day notice. And then you have to essentially, you're supposed to be done with the work in 90 days after they leave. Sometimes if you're not done, if it's really substantial, it's okay, because things just take time, but you really have to be in the process within 90 days of them leaving. Though those are pretty much the big changes that happened. There are some changes to the actual notice that you have to give in terms of information you have to give them if they want to come back. Once you do a substantial renovation, you're not required to offer them back the unit when it's done at the same rent, but you do have to let them know that they have a right to apply for the unit. I don't know why they make you say that, because that's just the law. They can come and apply for the unit if they want, and they can pay market just like everybody else. But they do require you to do that. That's the big change. So those are the two big changes that happened with 1482. The next big change that happened is 8012, and that's the security deposit law. Under the existing law, and this is effective July 1, 2024, under the existing law, when you signed a lease with someone, you could choose to take up to 2 months security deposit from them, or if you gave them a furnished unit, you could take up to 3 months security deposit. On July 1st, that is a piece of history. You are now only allowed to take a 1 month security deposit anywhere in the state of California, furnished, not furnished, nobody cares. Get 1 month security deposit. That's it. SB 267 is the other big one, and it pertains to Section 8. Now, if you hear other people talk about this particular law, you might hear them tell you that the way it works is that if you are allowing, or if you are having a Section 8 person to apply for one of your units, you have to tell them in advance, here, you can choose to either have me run your credit, or you can give me alternative form of income to prove that you can pay for your part of the total rent, right? Yeah, that's certainly one way to do it if you'd like. But if you run their credit and their credit is fine and you're going to take them, then that should be the end of the conversation. You're going to say yes. Why now offer them alternative credit? Meaning, why should you offer it to them in the beginning? Just run their credit, which you're allowed to do, right? And then if the credit's bad and you want to say no just based on the credit, then say, all right, fine. You have some sort of alternative means of verifiably letting me know that you can pay your part, right? So, and you do have to offer it to them in writing. A lot of people ask after I tell them that this is what you have to do for Section 8 people, they ask, can I just not do Section 8? Can I just tell people, yeah, we don't do Section 8? Nope. You are not allowed to have those words come out of your mouth or out of your fingers. Don't ever say that. Now, there are ways of saying no to people that don't necessarily involve breaking the law, but they are some kind of skirting the law, right? But I like to tell my clients, don't ask, am I allowed to do this? Ask, how much trouble will I get into if I do this? So by looking at it from that perspective, we can find solutions which help you be a little bit more discerning in how you let people into your apartments without necessarily giving them evidence which would support claims against you. That's really what we are looking to do. We're looking to screen very, very well, because the people who screen the best are the ones that call me the least. You want to know how to win an eviction? You win an eviction before the tenant ever signs the lease, right? And that's by screening really, really well and being very discerning. And remember, you're fighting a war. right? They're playing very dirty. They are passing new laws every time to make it harder and harder, or trick you into thinking that it's harder and harder to say no to anybody. A lot of people think that because of the new Section 8 law that came out a few years ago that says you're not allowed to discriminate against someone based on source of income, that means, well, if someone's Section 8, I just have to let them into my apartment? No, it doesn't mean that at all. It just means you're not allowed to give them evidence, which would suggest you're not allowed to discriminate against them because they have a government source of income to pay their rent, right? But the question of why you said no is really a broader question. You can have a Section 8 person that you would say no, you would say yes to, except for the fact that you do a criminal background search and you find out they used to be a serial killer. Well, you should say no to that person. And it's got nothing to do with Section 8. And it's perfectly legal for you to do that, right? So just because someone's Section 8 doesn't mean you have to say yes. And just because someone has good credit doesn't mean you have to say yes. Just because someone has good income doesn't mean you have to say yes. You don't have to let every person who applies into your apartment. And there are ways of saying no, which we could talk about privately. But anyway, so with the Section 8, that's what the deal is. If you want to say no to someone and you want to protect yourself, just give them an opportunity to present to you the verifiable source of income. Again, I'm not saying you have to say yes to them. You just have to tell them, here's another opportunity to add something to your application. That's it. Those are the three major big changes. They added some other stuff, but it's not super duper relevant. So I wanted to make sure to have a lot of time to answer everybody's questions today. So I wanted to move on to some of the stuff that's happening or that happened in Los Angeles and explain. The big thing that happened in LA is called the Just Cause for Eviction Ordinance, or the JCO, people call it. What that did is it took properties that are not rent control, and it doesn't put them under rent control. But what it does do is put them under eviction control. And a lot of people don't understand that most rent control ordinances really have two parts to it, and they're very different. One of them is rent control, and it's exactly what it sounds like. It regulates the amount of rent that you can charge to people and how much you can increase the rent, to whom you can increase the rent, etc. Then there's the eviction control part. Now, the eviction control part is very different. That's regulating not how much you charge, but when and how can you terminate a tenancy. Rent control, at the end of the day, is still governed by what's called the Costa-Hawkins Act. It's a state law that essentially says there's certain kinds of rent control that is not allowed. And so, for example, one of the things that's not allowed is if a city had a rent control ordinance already in 1995, their rent control, they cannot put any properties under rent control past the day they started their ordinance. So as a result, in LA, no property can be under rent control if it has a certificate of occupancy, which is after October 1st, 1978, right? Now, Costa-Hawkins doesn't say anything about eviction control, which means any local ordinance, any local entity, city, county, etc., can go and put eviction control on any of the properties inside their city limits or county limits, and Costa-Hawkins doesn't have anything to say about it. And that's exactly what the city of LA did. And this is not new, because West Hollywood and Santa Monica and a whole bunch of other cities already had this. They just joined the club, so to speak. And so what it means is that now, even if you have a condo or a single family home, which is not rent control, the concept of just sending them a 60-day notice and telling them you got to leave for no reason is now out the window. Even if you rent a single family home, and even if it's the house that you own and you decided to go see Europe and Asia for a year, and now you come back and you want the renter to leave so you can go back into your own house, you can't just give them a 60-day notice. You're going to have to go through the process of filing a declaration with the city and give them a 60-day notice for a specific reason, and then also paying them relocation benefits. The relocation benefits that you pay, even in the situation I just told you about, ranges from about $9,000 to a little over $24,000. And it depends on who's living in the unit. In other words, is anybody in the unit 62 or older, disabled, or a minor? In which case you get the higher amounts. And then have they been living there less than 3 years or more than 3 years? And again, less gets a little less, more than 3 years gets a little more. And so if you're more than 3 years and you have one of those people in your unit, which makes you qualified, you're going to be paying that person $24,650 unless it's a single family home and you don't own more than 4 units and the single family home inside the city. So in other words, if you're a mom and pop, you might be able to get away with single family home, giving them only 1 month. That only works for single family homes, doesn't work for condos, even if that condo is the only unit you own, right? Then you might qualify for a different mom and pop discount where the numbers are lower, but you're still going to be paying them in the thousands, right? So this is very different than AB 1482 because the just cause for eviction ordinance largely mirrors a lot of the AB 1482 eviction regulations, but the relocation amounts are much, much higher. Because even under the new AB 1482, the SB 567, which we were discussing a few minutes ago, the relocation is still just the 1 month's free rent, which everyone can live with. But when I tell people in LA the relocation amounts, there's a lot of sticker shock. And I can certainly understand that, especially for mom and pop landlords, but this is the reality. And so everyone should know it and just understand it. By the way, I'm going to sell the property is not one of the reasons that you can use to evict somebody, right? So just because you're going to sell the property doesn't mean that you can evict somebody. You're going to have to either buy them out through what's called a cash for keys program or sell it with the tenant inside it and let the person who is going to live there kick them out because I want to live in the house as the landlord is one of the reasons, right? Or I bought this house for my kids to live in. That's totally fine, right? But the person selling the house can't say that because they don't live in it. They have a tenant, obviously, and they're not going to live in it because they're selling it, right? So this is something that brokers also have trouble wrapping their mind around, and sellers have trouble wrapping their mind around. They're like, it's my house. I want to sell it. How am I supposed to show it if the tenant is inside? How am I supposed to clean it up and stage it if the tenant is inside? You don't. That's what the law is, unless you buy them out, right? And the buyout process, that is completely voluntary. So when people say I did a cash for keys, it means they made a voluntary agreement between the tenant and the landlord for that person to leave on X amount of days for Y amount of dollars. If you can agree to that, fantastic. You can make a deal. So that's mostly what just cause for eviction ordinance is. It would take me a really long time to go through all the different reasons that you have to evict somebody. Like I said, most of the ones from 1482 got implemented here, but the usual suspects are here in terms of not paying the rent, breaching a material obligation of the lease, with some exceptions, causing a nuisance, unlawful subletting, things like this. Most of that stuff is in. And most of the no fault is basically, I'm going to move in, I want to demolish the property, take it off the rental market, or do a substantial remodel. And then there are a bunch of other things which, again, mostly don't apply. Another few of the big things that happen in LA is, number one, you now, if they fail to pay the rent, you have to wait until they meet a particular threshold in order of owing you money in order to evict them. So the example I like to give is this. Let's say you are renting to someone who's been living in your rent control unit for 30 years. They're paying 30 years ago rent, and their rent is $800 a month. Okay. And let's call that a 2-bedroom unit. The threshold that they have to meet is the amount that the federal government, the HUD, sets as the fair market value for a particular bedroom count unit in your area. So they have the prices that they consider to be the FMR, fair market rental, for everything from efficiency, which means 0 bedroom or studio, all the way up to 4 bedrooms. Each one of those has a price. That amount of money is how much they have to owe you. Don't get confused. A lot of people said, oh, now they have to owe you 2 months rent. No, they might be able to hit the threshold with 1 month. They also might not hit the threshold with 2 months or even 3, depending on how much they owe you. So for example, let's use the guy that I was talking about. He's paying $800 a month. He's got a 2 bedroom in the city of LA. After month 1, the threshold is $2,544 in 2024. Month 1, he doesn't make it. It's $800. Month 2, $1,600. Still not good. Month 3, $2,400. Still not good. Month 4, right? Now he's at $3,200. Now he has crossed the threshold and you can evict him. You can at least give him a 3-day notice and start the process. The 3-day notice is for all 4 months. Not like you have to start from that 4th month. So you're going to give him a 3-day notice for $3,200. In fact, you have to, because you have to show a 3-day notice where the total amount that he owes you is more than that threshold, right? The studio is $1,777. The 4 bedroom is $3,600. And obviously the 1 and 3 bedrooms are numbers in between. $2,006 for 1 bedroom, $30,263 for 3 bedrooms. Go online, these are easy numbers to find. But those are the thresholds that you have to hit in order to evict someone. What it does is it delays your eviction. Now, fun little fact, what this does is actually make it something like impossible to evict certain Section 8 people. Why? When you get Section 8, you're allowed to keep taking your Section 8 portion and have the person who's paying their portion of the rent be in default, right? But let's say your Section 8 person is living in a 2-bedroom unit and their part of the rent is $200. Let's also say that they never pay their portion ever again. Remember, you can only go back 12 months in any UD, right? So if you give a UD is unlawful detainer, fancy name for an eviction. If you give a notice, you cannot go back more than 12 months from the date of the notice. So if you're giving your notice in February of 2024, the earliest month you can have on your notice is March of 2023. Let's say since March of 2023, our friend, the Section 8 guy who pays $200 a month, or is supposed to pay $200 a month, never pays his part. So do the math very quick. You can see at the end of the 1 year, he only ever owes $2,400. That's the most he can owe. And you can't evict him for the whole rent because you're getting the Section 8 part. So what ends up happening is, for that situation, he never has to pay his Section 8 part, ever. At least not for purposes of eviction. You'll never be able to hit him with a notice for more than $2,400. $2,400 is less than the $2,544 threshold. You can sue him for the money, take him to small claims. You can take it, if it lasts for years, you can take him to a regular civil court and get a judgment for the money. But under the conditions that I just said, you'll never be able to evict him. And that's the situation. This phenomenon has been brought to the attention of the city. It's been brought to the attention of a judge overseeing a lawsuit about it. And they almost got it kicked out. And then the judge changed her mind and did not give the win to AGLA. Now they're having to appeal the case. But it's a really stupid law, but it is on the books and we do have to follow it. There's one thing that came out and everyone was hooting and hollering about it, and I've never actually seen it happen yet. Basically, if you give someone an increase that is more than either 10% or the CPI plus 5%, which is equivalent to the max that you can give under 1482, if you can somehow give them an increase that's more than that, if you're allowed to, and they decide to move out because they can't afford the increase, you have to pay them relocation benefits of 3 months worth of their rent plus $1,411 in moving costs. Haven't really seen it happen so far, but it is a thing that is out there. In terms of moratorium, essentially, as you probably already know, moratorium has been over for in the city of LA for about a year now. And in the county of LA, it'll be a year at the end of March. That means all the rent is essentially come due. At least in the city of LA, in the county of LA. If it's outside the city, then by April, it'll all come due, notwithstanding any COVID defense. So it doesn't matter if they didn't pay you the whole time during COVID, they now have to start paying up the money. So if you have people who owe you money from March 20 through January of 23, right, we can now start evicting them, notwithstanding COVID. Now, in my office, we were evicting those people for 2 years, right? All through COVID. Because we actually read the law. It turns out you can do that. But now, notwithstanding the COVID defense, you should be able to go after those people. In the city of LA, again, the rent limit that they set until June is 4%. Plus, you can get 1% if you pay for electric and another 1% if you pay for gas. By the way, this does not mean that you pay for the electric for the common areas of the building. You'd have to pay for the electric for the actual unit of the person whose rent you are increasing. Same goes for the gas. If you say, well, I pay for the gas, and that's how we heat up all the water for the entire building, that's not what is meant. It means you pay for the gas inside that person's unit. You pay for their stove, or the gas that's in their stove. If you do that, you can tack on an extra 1%. So the max that you'll be able to tack on is 6%, right? Total. Those are most of the main LA changes. So I'd love to take everyone's questions. So let's see. I know that Julie had her hand up first for a long time. Julie, your hand must be very hurting at this point.
So my question is qualifying for a rental. Are there laws about, like for me, I've been doing 3 times what the rent is.
Okay.
They have to have good credit. And so are there any laws around what I set as my standards to be able to move into a rental?
Nothing specific. They just have to be reasonable, right? And you have to apply them uniformly. So you can't.
So go ahead. With the Section 8.
Yeah.
So obviously, well, I don't know if it is obvious. If I have that rule set, they still have to have income 3 times the rent. But does that rent get included?
This is where it gets a little fuzzy. They have to have income, proof of income sufficient to pay their part. So if the Section 8 person's part is $200 and you want to say, well, you have to have at least make $600 a month. Okay, no problem. But you cannot say that they have to have enough income to pay the whole rent because they're not paying the whole rent. So if you say I have a Section 8 unit for, I've seen them go for like $3,500, right? Because it's an affordable unit, and the person's paying like, let's say $1,000. You can't tell that person. You can't say, well, he doesn't make $11,000 a month, so I'm not going to qualify him. You can't do that. You have to say, does he make $3,000? Everything has to be based on the amount of rent they're actually required to pay. Because the rest of it you're getting from the government.
Yeah.
And they're good for it. If they don't have it, they'll just take it from me.
Okay. So I'm not in LA. I'm in the Central Coast. And it doesn't matter. So that law is
statewide
with Section 8.
Mm-hmm. All right. Thank you for that question. Letty?
Hi, can you hear me?
Yep.
Okay, so my question is more on the tenant side. A tenant signed a lease, they did a tour of a property. And their days in, maybe about a complete 5 days. Is there any way to get out of that contract, 11-month lease, due to the living conditions that were discovered in the one night that tenant spent a night at that property? Meaning,
like as on behalf of a tenant?
On behalf of a tenant, yes.
So we don't represent tenants.
Okay.
And this is being recorded. So I'm going to
Okay.
respectfully decline to answer.
Okay, no problem. Thank you.
No problem. Dan Reed.
Yeah, hi. I want to explore what your analogy was of you went off to Europe for a year.
Yeah.
My situation is I've got a single family house. It's not Section 8, but I am thinking about doing that. Maybe not Europe, but just going away. And then, I'll just rent this house. But then if I decide I don't like living somewhere else, I don't want to come back to my house in California. So at the end of the 1-year lease, can I just decide not to renew and then everything's all good? Or
Where's your house, Dan?
It's in Riverside County near Temecula.
Okay, so a bunch of those laws that I was saying are for the city of Los Angeles.
Okay.
So if you want to lease it out to someone, all you have to do is make sure that your lease has the AB 1482 or Tenant Protection Act exemption language. But when you give them the lease, there's language that the law provides that you can tell them, hey, this single family home is not subject to the Tenant Protection Act. And as long as you've done that correctly and you've put it in your lease and you have the regular lease is good, then you will be able to kick them out on a regular old 60-day notice without paying any rent.
Okay. Could you repeat that AB law number again, please?
1482.
Thank you.
Niv, we have a couple of questions in the chat.
Okay.
So the first question is from Todd Williams. This is back when you were discussing the original California laws. Does it apply to mobile homes?
Mobile home parks have their own thing. So they have their own protections. I'm going to check real quick. We don't do a lot of mobile homes, but my recollection was there were some exemptions for mobile homes. Hold on one second. Some of it does and some of it doesn't. So if you have mobile home issues, that's definitely something we should discuss separately because, first of all, a lot of cities that don't have rent control or eviction control protections do have a mobile home protection ordinance. So it really depends on what city you're in. And then, like I said, mobile homes have their own entire civil code section to talk about how and when you can evict someone, what are the reasons you can evict. It's typically, and it's statewide, and it's typically more restrictive than 1482 is. So mobile homes are actually kind of complicated.
So just to kind of differentiate, is there a difference between if the tenant owns the home or if it's a park-owned home?
Nope. Under the mobile home law, they protect both people.
Okay, great.
Yeah.
We also have another question from Anna.
Okay.
If you have a contract and owner wants to go live there when the contract expires, will that be penalty free?
Where's the house, Anna?
Anna?
Or the property, whatever it is. First of all, is it a single family home? And second of all, where is it?
See if we can get her up here. Hang on.
As you can see, where your property is and what kind of property it is make a huge difference to the answers that we give.
Anna, where are you, Anna?
She's muted.
Okay, I don't know if she can hear us at all, but if you can answer that question, we can get an answer for you.
Yeah, Anna, can you hear us or still there? No? All right.
We'll defer that to it is location specific.
Yeah.
Yeah.
Okay, so Vicky says, can I use the term best qualified credit score, income, and landlord's input? So Vicky, I don't understand the question.
Okay, that's why I took myself off. So my question is, I am a landlord, and I always term, and I hope I'm okay, I use the term best qualified. And I go through the credit report because I do have a minimum requirement. And the credit score, I use their income, the 3 times income. course, landlord's input. Because I'm trying to find out, do they have wild parties? Do they pay their rent on time? And so I'm
prior landlords. Okay, fine.
talking about screening tenants. And
Okay.
and I use that term all the time, is best qualified. Even with Section 8, I always accept it because somewhere I learned you're always supposed to accept applications. And after I go over some of my requirements, they normally don't apply. So I just want, I mean, I have accepted an application, but they normally don't qualify.
Right. So now you might want to change your advertising to say best qualified credit score or proof of alternative source of income if you have government assistance. Because it's not really just Section 8, it's any sort of government assistance.
Got it.
It doesn't mean you have to take the person.
So it shouldn't be income. It should be qualified, or can I say qualified income?
Yeah, qualified. It's really the word you're looking for is verifiable.
Verify. Okay, got it. Okay.
Yeah, verifiable is the word from the code.
And the reason why the tenant didn't, Section 8 did not get it because she had the income, she had the voucher from the Section 8, she had the money, and she had a decent credit score, but the landlord's input was, she said she kept the house dirty, she had holes in the wall, she had, just a bad review.
Those are all perfectly legal reasons to say no to someone.
Yeah, so that's the reason why she didn't get it.
And when they call you and ask you, why did you say no to me? You should not say any of that.
Right. Yeah.
Don't tell them. Because anything you give them, especially not in writing, but don't even say it over the phone. Anything you give them can be turned into discrimination. Anything. Let me use yours as an example. Okay? The landlord prior told me you keep your house in disarray. It's a complete pigsty. Oh, I'm a hoarder and I've been diagnosed with this psychological disease of hoarding that makes me disabled. And now you're discriminating against me because I'm disabled. That's illegal.
Got it.
I can twist anything the landlord says into some kind of a discrimination, whether it's race, national origin, sexual orientation, perceived sexual orientation, gender, religion, source of income. I had someone complain to the city of Santa Monica because they got discriminated against based on source of income. You know what their source of income was? An expiring COVID voucher, a voucher that was only good for 12 months. And he had no income whatsoever other than that. So in other words, it's like someone who won a $10,000 lottery scratcher and has no job other than that. And the landlord said, no, that's not sufficient income. And the city agreed with him and we're yelling at the landlord. You can take anything and make it into discrimination. So generally speaking, not a good idea to tell them what you're thinking.
And you know what? I do that when I do tell them when they don't get the house. This is for everybody. I say, thank you so much for applying. Unfortunately, another family was awarded the home.
Don't even say that.
Oh, not even that? Oh, okay.
Oh, say nothing.
But you have to get back and tell them they didn't get it.
Why?
Well, they normally, because they've applied, they gave me all the information, but they didn't. Another family was to my books best qual. So what do you say when they call you up and say, hi, I'm just following up on my application?
Nothing. I don't know. Did I get it? Exactly. Dan said, learn the art of ghosting. That's exactly right.
Oh, wow. Okay.
Hey, thanks so much for the call, but we're still reviewing applications.
Yep.
Okay.
It could be like 2 months later. They could say, how could you possibly be reviewing applications? Play dumb. Basically say, I'm sorry, we're really bad managers. We're just super slow at this. No one can fault you for being slow and dumb.
Okay. Okay, interesting.
Or vague.
Or vague. Or vague or rude by not calling them back. But like I said, they're playing dirty. You're running a race where they get, one of those little things in the airport where, you know, the floor moves for you.
Mhm.
And right next to them, you're running in mud with things you have to jump over and dragons that come out and bite you. That's the way they've set up the race. So you cannot play 100%, you know, by the book. Because if you do, then you just let in every Section 8 person. And you'll let in every person who comes because you're afraid that someone might say you're discriminating against me. And you're going to end up with a building full of people I have to evict. Wonderful for me, but not good for you.
And can I put it, when they ask me what is the credit score I'm looking at, can I give them a number?
No.
You cannot.
Well, I mean, you can if you want to, but it's like, just say good credit score.
Okay, interesting. Thank you. Okay.
Yeah, question on that real fast before we move on. I was under the impression that by running someone's credit report, that if they requested a copy of it, you're obligated to give it to them.
Sure, give them the credit report. No problem.
Yeah, a copy of the report.
Sure.
Yeah.
The law is, technically speaking, if you say no to someone because of their credit score, then you have to tell them that's the reason.
Okay.
Who knows why that's the reason? Only you and the other people in your head.
There's many in there.
Well, there are ways around this, people.
For sure.
Gotta be smarter than the tenants.
This is true. This is true. Dan, why don't you jump in there?
Thank you. Another follow-up question to my house I'm thinking about. I'm considering and researching turning it into a boarding care. Would I need an attorney like you to assist me with that because it's rental stuff, or is that another like more business side attorney that I need to consult with?
When you say boarding care, do you mean basically like a 6-unit nursing home?
Yeah, it wouldn't be that many beds. It'd be probably more like 6, but
Right,
yeah,
exactly.
small. Yeah.
6 is the max for most single family homes, and there's ways you can chain them up so you can make up to 18. But yes, you would need licensing. That's a whole different kind of thing, right? Maria's saying RCFE, correct? That's a nursing home is different from an RCFE, also correct. It's a different animal, but one way or another, yes, you need a license to operate a place like that. So if you're going to do that, you're going to need number one, a healthcare regulatory person. Yeah.
But I'm probably still going to need somebody because I had my mom in one of those and I still had to sign like a lease for some period of time. So there's still rental lease agreements and stuff that come into play. And would they still fall under what you're talking about, or is that still just a completely different thing?
It kind of depends. It's a little, you're talking about leasing a home from a different person?
No, it's my home. I'm just.
Oh, it's your home. No, once it's your home and you're using it for the RCFE, it's completely different. You're not really signing leases. You're signing other documents which provide for a lot more than leasing, because you're not offering the people just a place to stay. The fact that they're staying there is sort of secondary. The main thing you're offering is the care.
Right.
And the services. That's really what you're signing up for.
And what kind of an attorney would that? Is that like just a business?
Healthcare attorney.
I'm sorry, what kind?
Healthcare attorney.
Okay. All right. Thank you.
Yeah. Who's next?
Ruby, are you on? 100, she got her question answered. Okay, we can move on from that one. And Michael Kane also asked, are the San Diego regulations slightly better than LA?
Depends on where. City of San Diego, I guess a little bit, but not that much. Outside of City of San Diego, yeah, because there's places that just don't have it. The County of San Diego restrictions, like the LA County ones, only apply in the unincorporated parts of San Diego. So San Diego's getting bad, but it's not as bad.
They're trailing.
Yeah, that's pretty much how San Diego rolls.
Yeah. OC still friendly?
Everywhere except for Santa Ana.
Okay. That's good to know.
Yeah.
Good to know.
Dennis, can I ask you a quick question?
Sure,
Yeah.
go ahead.
I'm on my brother's phone, so it was me that was asking that question. In regards to like outside, would that be considered like El Cajon area, Lakeside, or is that still part of like San Diego County? When you said
El Cajon, I think that's where my wife's family is from. No, it's still part of the city of San Diego. You have to go and like kind of check in LA County. We have a website called lavote.org, and you put in the address and it gives you exactly what city it's in and the congressional district and the Senate district. It's the whole thing. I don't know if they have that for San Diego. I've never had to check. I'm fairly certain that El Cajon, at least parts of it, are not its own city. A lot of the times when I want to check if it's an actual city or if it's a neighborhood, first I just write city of blah 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 in Google, and if it comes up as its own city and has its own website, it's its own city. But then you have to check to see where your property really is. Because just because it says a certain address in the mailing address doesn't mean it's within that real city, right? So it might say City of San Diego for your address, because that's where the United States Postal Service puts that place. That has nothing to do with what actual city it's in, right? In other words, is it in the city limits of San Diego or is it on the border? And so, for example, we have properties in LA where it says Los Angeles, California, but it's not in the city of LA. It's in the unincorporated parts of LA County, which is a completely different ordinance and completely different law and a completely different place that you have to send the 3-day notices. So you really have to know exactly what you're dealing with. Before the lavote.org, I would literally take a Google Maps, see where it is, find the city limits on a different thing, and map it out by hand and see, is it in this city or is it in that city? And every now and then you'll find the one building where the city limit runs through the middle of the building.
Thank you.
Yeah.
For sure.
Next.
Raquel Thompson was asking, how does being evasive work for and against your brand potentially harm your business? And I asked for clarification as an agent or a manager, and she said, as a manager landlord.
Remember this, as a manager landlord, I've never really seen any landlord Yelp reviews that are 5 stars. It just really doesn't happen. Right? Most people don't like their landlord, and most of their complaints are stupid. And everybody who's a landlord knows that. Tenants tend to be extremely entitled in terms of they're renting a house, they're renting an apartment in a building that was built during the Civil War, and they're expecting it to be to the standard of some brand new apartment building built in Bel Air. That's just not realistic. On top of which, a lot of tenants don't understand that even those apartment buildings that are built in Bel Air have problems. Brand new houses that cost millions and millions of dollars have leaks. Sometimes it's not because the building is old. It's just because it gets leaks. You know, my house was built in 2021. It's got leaks. That's just how construction works. Someone sees 7 flies in their house and they're saying, "Oh, it's uninhabitable because I have vermin." You know, during the summertime, I have flies in my house, right? And like I said, it's a brand new house. You know why? Because flies are a real thing. Now, if a person's got a family of mice and rats living in their unit, obviously that's unreasonable, right? But and that's something they should be complaining about. But in terms of the brand, again, I don't worry so much about the brand in terms of being a landlord. I think most of your branding, again, I'm not a marketing expert, but if you got a couple of people who are saying, "Oh, they're non-responsive" or whatever, if you're offering a really good apartment for a competitive price in a good area, I don't think it's really going to affect your brand. In terms of a manager, tenants are not necessarily your clients. Owners are your clients. So you want to be concerned about what owners think of you as a manager, not what tenants think of you as a manager. Tenants aren't hiring you.
And if you're an owner manager, you just tell yourself you're wonderful every single day of the week and move on.
Yeah.
Yep. Yep. Interesting question here. We have a question from Carson Edgar. He is in Michigan, but he says, do you see these laws going into other states?
Detroit, I'm shocked, doesn't already have rent control. There are certainly some blue cities in Michigan, but most of this doesn't exist in other states because they have a far more balanced political reality, right? Or they have an imbalanced political reality, but it's in favor of more, conservative policies, which are very much against eviction control and against, rent control. So, for example, even Austin, which is a blue city, is in Texas. And if they try and pass rent control, I think there's probably going to be a riot. So they probably won't do it. In Detroit, do I see it happening? Absolutely. Outside of the big city, probably not.
So Washington State was also a question if you're seeing a lot of stuff going on in Washington State.
The entire, no, it was Oregon that passed statewide rent control right before California did. And then I think Washington did it there as well.
Okay.
So yeah. The city you were questioning about was Castaic, unincorporated area of LA County. So Anna, can you please remind us what your original question was?
Let's see if I can scroll up to it real fast.
Yeah. Wants to go live there when the contract expires, will that be penalty free? Okay. Castaic is, yes, unincorporated LA County. No. So basically, unincorporated LA County is like LA City, where they have eviction control. So you're going to have some sort of a reason for evicting the person, even in a single family home. Oh, wait. No, not in a single family home. Sorry. It depends on what kind of property it is. Yeah. So, sorry. Next.
Vicky, you're back up again.
I know LA's crazy right now. And, a couple of years it got worse. Do you ever see that changing in the future?
A little bit.
Yeah, because it's so, owners, we're all looking for units and it's just, there's opportunity there, but everybody's running away because of the rules and the laws. And so
a little bit. Let me explain. There are three people who are on the council, which is Nietzsche Raman, Hugo Soto Martinez, and Ulysses, I always forget the full name. Those three people are with DSA, Democratic Socialists of America, okay? And they put the Democratic in just to appease people so that they don't call themselves what they really are, which is just socialists, right? They're honest to goodness socialists. And they're the ones that continuously push all of these very, very anti-business regulations. They're also the people who are defund the police and basically making it a worse place to live in. And there's a lot of people who are in what we call the silent majority who are really sick of it. And so there's this huge push now from certain groups to support centrist candidates. Okay, so I'll give you an example in CD4. And if you're interested in this and in supporting this, there's a website and a group that I'm a part of called Thrive LA, THRIVELA.com. Go take a look. Thrive LA is not trying to put up hard right Republican candidates. In LA, that's stupid. That's a waste of time. Okay. But what they are trying to support are normal, centrist, reasonable candidates who are pro-safety, pro-police, pro-business, and if not pro-business, at least not anti-business, right? We're going to do normal things to bring LA back to a sense of normalcy and try to pull it off of this ledge that it's about to fall over, which is this socialist nonsense, okay? So this kind of movement, and there are, lots of groups like this, or at least a few different groups that are going on like this, I see as having some inkling, some light at the end of the tunnel if this starts to work. So in CD4, they're pushing this guy named Ethan Weaver against Nitya Raman. And if he can win and take one out, that means you can take out the other ones when they come up for election, right? And if you can get people to really understand the benefit of having normal people run your city, and then yes, I do see some things, at least if not getting better, then at least not getting worse. I think once you start giving stuff away, it's really hard to pull it back, unless the pendulum really starts to swing, and that I just don't think is realistic. But at least getting it under control before it completely goes off the ledge. I'm cautiously optimistic that will occur, because the issues that we're talking about today, landlord-tenant issues, are really not the only issues that are vital to the people who are living in the city of Los Angeles and even in the county of LA. There's the homelessness, there's the public safety, there's the crime. There's all these things where these socialist elements and very, leftist elements, far leftist elements of the city are just torching the city, right? Just setting it on fire. And people are seeing that. And you can be as liberal as you like, but no one wants to live in a communist city. No one's like, what was really good? Moscow's 1969. That was a fun place to be. No one ever says that. It's because it's not true. It sucks.
Well, there's definitely some truth in that for sure. I think one of the other things that is of a concern to people that may try to turn the tide on what's been happening here is a lot of these battles are having to be fought in court, and it's unfortunate. We're seeing it play out in elections. We're seeing it play out in just community rights. One of the things that we saw, and I was very surprised that it did not get farther in the courts, was when they did the COVID restrictions and COVID lockdowns and said, you don't have to pay your rent. I mean, as a broker, I was surprised that nobody took up a lawsuit against that, citing that it was a government taking, or,
They did.
They did? Okay.
They lost.
I heard about it. Yeah. But they didn't appeal to a higher court, or was it just?
It's still being appealed.
Okay.
But the problem is very, very few judges want to be that guy. The one that said COVID restrictions are illegal or a taking. So now city or anybody else who had COVID restrictions, go pay these landlords who are lining up $5 billion.
Mm-hmm.
If you don't think the judges take this into account, you're lying to yourself. It's really, that's just what happened. I think the judges looked at it and said, you know what? I'm not going to be that guy. You want to take it up at the Court of Appeal? Let them be the ones that cost the city $5 billion. But it's not going to be me.
Right.
And they find a way to find an answer and then wiggle their way back into it. The reality is that, at least in LA, there was no COVID moratorium. It was a COVID defense that they put. It basically said you are not allowed to evict someone if they couldn't pay the rent, and the reason they couldn't pay the rent was because of a COVID-related circumstance. We actually read that and said, oh, so if you can pay the rent, or if the reason you can't pay the rent is not related to COVID, you could be evicted, even during the moratorium. And guess what? We were right. We filed thousands of evictions all through 21, 22, 23 for COVID income, for COVID rent, and evicted thousands of people. Not that I'm happy to evict thousands of people, but the way I look at it is I got back landlords' properties that weren't being paid for.
Right.
And if you actually read the law, it's very enlightening.